All right. Hello, everyone. Welcome to our live stream. My name is Bradley Chaplick. I am a condominium lawyer at Horlick, Levitt, Lella, and it's my pleasure to be here with you this Wednesday at noon for our 40th Ask Us Anything live stream session. If you're new to the live stream, you can subscribe below, and if you hit the notification button, then you'll be notified of additional videos. We hope to return with some case law corner soon. There have been some interesting new cases in 2021, and I don't see anything in the chat yet. So if everyone can just confirm that you can hear, or if someone can type in that you guys can hear me, that would be really great, because I always worry that I'm just talking into a void and no one can hear me speak. So let's cover off what we want to talk about today. So we want to, we're going to talk about the update on the lockdown order and future easing of restrictions. We'll discuss a little bit of the best practices for reopening. We have a case law update for you, and I'm here to answer all of your questions. And I still don't see anything in the chat. So if there's any questions, type them into the chat now, and that will allow us to get this discussion going. Oh, there's some people saying, yeah, we're not talking into a void. People can hear me. Okay, great. Wonderful. Great. Everyone's typed in that they can hear me. That's fantastic. So think about your questions. Throw them into the chat and I'll answer them. And while we're waiting for those questions to come in, let's just talk about a little bit of case law. I love reading condo cases. I get a lot of enjoyment out of them. I love learning new things, and I love how the law is always changing. But the fact that the law is always changing makes things difficult for you as condominium directors, unit owners, and managers. And so something I can do to help you is to tell you about some of the new things that are happening in case law. So first, let's talk about cases from the Condominium Tribunal. So there were a series of two cases involving the same parties. The owner's last name was Abu El Naj, and the condominium corporation is PSCC 935. I put links to both cases in the video description below, so if you want to read the full cases, you can. And I put it's Abu El Naj number 1 and number 2. So this is a records dispute at the Condominium Authority Tribunal, and the decision is heavily impacted by the fact that the condominium corporation did not participate in the hearing phase of either application. And so because the condominium corporation did not participate, they got a really bad outcome that they would not have got had they actually attended the hearing and participated in it. And I think you would have seen a different result. But the fact is that the tribunal made these awards, and now we have to be aware of them, although I don't think that they would stand up as strong precedents in the future. So here's what happened. So and I'm not going to talk about records that are like routine, like board minutes or anything like that. There's lots of cases about normal records that condominium corporations have to provide. I'm just going to talk about the stuff that was interesting or that I thought was a little bit unusual. So one request that came in was for quotes on a contract. So there was a security contract, and we would all acknowledge that a unit owner would have the right to request a copy of a signed contract for security services. It's a financial document, and it affects the unit owner's rights, right? So that's the spending of their money. So they want to see the contract. Okay, great. Everyone knows that's fine. But what about the quotes for the contractors that were not selected? Are those a record of the corporation? Prior to this case, it had always been accepted and understood that a quote that was ultimately not selected from someone who was bidding on a job was not a record of the corporation, because if it was, you would have to keep it. And there's no reason why a condominium corporation would have to keep these quotes. You want to hire a security company, you ask for three quotes, you choose one, you sign a contract. Why does it matter what the other quotes were that you didn't select from a record keeping perspective of the condominium? The answer is, of course, it doesn't. And so on that basis, we've always said no to those types of requests legitimately. So this is what the unit owner was requesting, and you would think that he wouldn't be entitled to it. But the tribunal, in the absence of the condominium corporation participating, ordered the quotes to be produced. They basically said there's no evidence from the condominium corporation saying that these aren't records, so we're going to order them. And so this is a cautionary decision for condominium corporations, and we'll get into more of that why, but I want to talk about some of the other questionable records that the condo was ordered to provide over the first and second case. So one was quotes. The second was the manager's monthly report to the board. So you all know what this is. I don't have to explain it, but for those of you who are not directors or who are not condominium managers, in the lead up to a monthly board meeting, the manager will often produce a report. That report will contain financial information as well as basically the manager's work product. And once again, this has been widely acknowledged as something that is, generally speaking, not a record of the corporation. It's the manager's work product, and they don't have to be produced. In this case, they were ordered to be produced, although they had to be redacted to remove any information that might identify a specific unit or owner. So again, we have past cases that says you don't have to give out the work product like this, but in this case it was ordered, again, because the condominium corporation did not participate, and also because there were specific references to the manager's report in the board minutes. So this is something that, again, you have to be aware of, that if you don't participate in these tribunal hearings, you might get these bad outcomes. So you need to put your best foot forward when you're facing a records request at the condo tribunal. More crazy stuff coming. So redacted copies of rule enforcement letters that were sent to other owners. So I think there was a letter between, or some sort of correspondence, and the unit owner said, well, are you just enforcing against me? And they said, no, we've enforced against other owners as well. And he said, okay, well, I want a copy of those letters. And typically, again, you would say records relating to other units or other owners are not producible. It's a clearly exempted record under the Condominium Act. Condo didn't participate. Tribunal ordered them to be produced but redacted. And they said any concern that the record relates to another owner can be resolved by just blacking out the person's name, unit number, and any other identifying information. I don't agree with that. I think that that's not the purpose of the records requests, that you shouldn't be entitled to see records at all, regardless if they're redacted, if they relate specifically to other units and other owners. And I think there's good case law out there that would support that view, to say that you can deny those records completely. But again, in this case, they were ordered. Not a good decision. So, and then the other one were complaints about the requesting owner's behavior. So the requesting owner went door to door with a requisition to request a meeting of owners, probably to remove the board, but it might be about something else, I don't recall. And the condominium corporation, they got complaints because the owner was going door to door and other owners were upset by this. They said they got emails from like 30 owners complaining about the guy's behavior. And so the owner said, well, I want to see those emails, or you have to admit that you were lying and they don't exist. And so, once again, this is typically these emails would not be produced. The condominium corporation refused to produce them on the basis that they're records relating to other units and other owners, and the tribunal ordered them produced but redacted. So all of these are records that I would have advised any condominium corporation to say you don't have to produce. And similarly, they're all records that I think if I went to the tribunal and argued a case on behalf of a condominium corporation, I would win. But in this case, they were all produced. And so the concern is that this case somehow becomes a precedent for future decisions and dramatically blows the door open on the kinds of records that condominium corporations have to produce. That's not good for condos. It's not good for owners who want their privacy protected. And so I think it's really unfortunate that the condominium corporation did not participate in the tribunal hearing, and now you're going to have this case out there that people are going to be citing and relying on, saying you have to produce all this stuff. When the reality is, had the condo just participated in the hearing and made basic arguments to the tribunal, they likely would not have had to produce any of these records, and they would have been able to rely on past precedent that says none of this stuff is producible because it's all private and confidential. So that's Abu El Naj, really unfortunate case. And I think it's a warning because you might reasonably think look, the condo tribunal knows what they're doing. They know what records have to be produced and what records don't have to be produced. Why do I have to participate in the hearing? Let the owner go to the tribunal, let them ask for the record, and the tribunal will just say, no, you're not entitled to it, relying on their own precedents, right? That's a totally reasonable thing that you might think would happen. But it's not. The tribunal is just going to listen to both sides' arguments. And if you don't respond and you don't put your arguments in, then they're just going to order the documents to be produced. And they'll say, well, that's it. It's not contested. I'm ordering it. So you have to participate in these tribunal hearings. You can't ignore them. And you can't just assume that the tribunal is going to stand in and make the arguments that you would have made had you been there. They're not going to. They've demonstrated that now in this case. And I think it's sort of a cautionary tale for boards and managers that they have to respond and take these tribunal cases seriously, get legal advice, and then participate in the hearing. And I think even just a basic participation, this condo would have been successful on all of these documents, and none of them would have had to been produced. So hopefully this doesn't become a precedent. Let's talk about another case. It's Y, or WEI, Way maybe, and TSCC 2297. Again, link in the description below. So what happened in the Way case? The condominium tribunal ordered the production of records relating to a legal action between the condominium corporation and a unit owner that settled. And so again, legal action, this is like crystal clear exemption, right? You're not entitled to any records relating to actual or pending litigation. And the law had always been that those records could all just be excluded by relying on that basis. But that's not what happened in this case. And in this case, the condo did participate. So the tribunal held that because the case had settled, there was no longer any actual or pending litigation. And they looked at the related concept of something called litigation privilege. So litigation privilege means that you do not have to produce documents that were created for the purpose of the litigation. Litigation privilege ends when the litigation is over. And so the condo tribunal said, well, we're going to take the litigation exemption and we're going to connect it to this concept of litigation privilege, and we're going to say when the litigation's over, the condo is no longer exempted from having to produce records relating to the now concluded litigation. Those records can now be requested. And so I think in this case, the unit owner wanted to know, there was something on the status certificate saying, or in the periodic information certificate saying there had been a relatively small legal dispute, $8,000, and it had and then it had settled, and the owner wanted to know what was the settlement, and whether it had grown into something larger or settled for something much smaller in terms of the financial interest of the owner. And again, my advice to this condo would have been, you don't have to produce this. This is related to litigation, but here it is, and the tribunal ordered it to be produced, the documents relating to this litigation. They clarified that they're not ordering anything to be produced that's protected by solicitor-client privilege. Solicitor-client privilege is lasting forever. It never expires. But just the documents of the litigation itself. So maybe the statement of claim, the statement of defense. I'm not sure what else would really be producible, but probably not the correspondence between the lawyers or anything like that. It's very difficult to imagine what would actually have to be produced and why. Anything that was filed in court's a public record anyways. So let's think about that for a second. When you go to court and you file your statement of claim, that's a public record. Any person can go to the court office and get a copy of that document and read it. So if someone's requesting copies of the publicly accessible records, why not produce them, right? It's something that someone could go and get anyways. There's really nothing, there's nothing private about it. Beyond that, I wouldn't really want to produce anything. I would claim privilege over it, and I would say there's no legitimate purpose in a unit owner requesting something that is not part of a public court file relating to litigation between two parties. Like what could possibly be the reason for it? And we've talked before about settlement and condos that talk about their settlements of litigation, and then that waives privilege, and then they end up having to disclose copies of the settlement documents. So one of the reasons why this decision is really bad is because condos sometimes will make settlements with unit owners on the basis that the settlement should remain confidential. And if the condo knew that the settlement was going to be disclosed to all owners, they wouldn't have done it. And so the unintended negative consequence of a decision like the Y decision is it will discourage condos from settling cases with unit owners because they'll be worried that they'll have to produce documents about the litigation later on, and I think it will make condos less likely to settle, and it's just bad for everyone because instead of having compromise with the assurance that it can be confidential, now condos are going to be worried that anything they write or do in their litigation could someday become a record that owners have the right to see, and it will make the condos less likely to compromise, more likely to take aggressive postures in their litigation, and that's bad for everyone because really what you want to do is settle your disputes on an economic basis and keep them private if you can because it's really no one's business. So, two very unfortunate decisions out of CAT. I've got a question in here from Yana, so I'm going to go to that question, and then we'll talk about a little bit more cases, and then we'll return to some COVID stuff, which you might all be sick of by now anyways. All right, case law. Question from Yana. What is the better way to create and pass a standard unit bylaw? Should the board do any work before contacting the lawyer? Okay, so I'll tell you how I do it, and sorry, just picking up my notes here. I'll tell you how I do it, and if that's the best way to do it, then great. But other people might do it slightly differently. So the way I do it is, first of all, it depends if you already have a standard unit schedule, and you're just amending it, or if you're creating one from scratch. So assuming that you're a new condo or newish condo, anything after 2001, you should have a list of builders' standard finishes provided to you under the Condo Act. It was required from 2001 that the builder would provide this. And so even if you don't have a standard unit bylaw, you have a standard unit definition in that builder's list. And so if you're passing a standard unit bylaw, then you're simply amending the list. And so what I would do is you have to find that list, send it to the lawyer, I will draft the bylaw, and I'll send it to you with everything the same, and then I'll basically ask you questions and say, here's what I recommend you change, and then it's done. It's very easy. If you have an existing standard unit bylaw or if you have an existing standard unit finish list, just make sure I have that information when you tell me to do the bylaw, and I'll draft everything. And then it's really easy. If you're an older condo and you don't have a standard finishes list, then I'm basically going to draft your standard unit bylaw, and I'm going to send you a blank schedule for you to put the finishes in. And then as a board, once you get that draft bylaw, you start doing the work of putting together all the finishes. I can even populate it with sort of like a sample list of finishes that just to give you a sense of what could go in those boxes, like placeholder things like, broadloom park carpet or whatever, just so you can have a sense of what goes where. But that's how I would do it. So I would say you don't have to do a lot of work before contacting the lawyer. Just let us know that you want to do it. We'll talk to you. We'll figure out what you want, and we'll design a bylaw for you. And then we'll give you your homework in terms of what you have to do to create the standard unit finish list at the right time. So I would say contact the lawyer first before you do a lot of work on it. Let us know, and then we can guide you in the right direction, depending on your condo and your circumstances. Amber, are there cases on record involving a condo corp requiring access to an occupied suite to perform non-emergency work during the pandemic where the resident owner wanted to refuse access? I don't think there's case law specific to the pandemic about access. It's just, it hasn't been that long, and cases take a long time to meander through the courts. There are cases upholding policies, so cases saying that you can't do renovations even if it's legally allowed, and things like that. So I would say there are no cases that I'm aware of, Amber, but I can tell you what my inclination would be, which is, you're talking about non-emergency work. I would want to clarify, are you talking about something that, even though it's not an emergency, is really necessary? Does it relate to health and safety? Is it part of a larger project? Is there a cost to postponing it? All of these things are important. Is access truly necessary, or could it be accessed from another place? What accommodation can you provide to people? So I have a condo that was doing window replacements, and in a sense, it's not an emergency, but it was a big, expensive project that needed to be done, and it had been long delayed. And the condo accommodated people and said, okay, we're going to provide you with amenities that you can use while we're in the unit, and that type of thing, to make sure that people had a place to go that was safe. So I think it's going to depend on your facts, but there's no case, and of course the courts are going to be sympathetic to individuals who are vulnerable people who say, I don't want anyone coming in, it's not an emergency. So, but if it's something like just inspecting a fire alarm, you really do have a right of entry, and there is not a lot of harm of having to go in, check the fire alarm, and go out again, because it's part of your responsibilities as a condominium corporation to comply with building and fire code. So things like that, you're going to go in. But for things that don't relate to health and safety, if they can wait, you're going to wait. If it can't wait because it's part of a larger project, you're going to provide some sort of accommodation for the person. Those are basically the different routes that this can go. Complicated question, very fact-specific, Amber. All right. WC. Hi, Brad. If the corporation has COVID-19 questionnaire just for the management staff, should that be extended to all staff as well as contractors coming in site to do the work to keep it consistent? WC, yes. You should have everyone who works on site for the corporation, not just property management, fill out the same health and safety questionnaire every single day. In fact, you're arguably required to do so. This has been enforced since September 26th. So yes, make everyone do the questionnaire every single day, and if not, they can't come on site. That's what you got to do. Archangel, do you believe that condo corporation is considered to be a refusal to provide records if a board meeting minutes is not approved? Is it not up to the board to have it? Is it not up to the boards to have board meetings? Okay. Wondering what the tribunal response would be, especially if the unit owner is requesting thousands of dollars for settlement. Okay. So if a unit owner is asking for a record and the record is not in its final form because it's in a draft, there is case law that says that records do not have to be provided until they are approved. So one example of this was a unit owner who asked for the draft minutes of the annual general meeting, and the tribunal held that they did not have to be provided to the owner until they were distributed to all owners in the ordinary course as part of the next year's meeting package in draft format. So that's a good example that you can use as a comparator. And then I would say the same thing about board meetings. You would say that the record doesn't exist because the minutes haven't been approved, and the draft minutes are not a record of the corporation. They're a work product of the board, and they're subject to change. So that's how I would answer that. I think the tribunal would agree with me. I suspect there's probably some case law out there that'll help you. And Archangel, if you want to send me an email, bchaplick@HLD Lawyers, I can give you more information, and I can send you the specific cases that I think are really on point. I've got a pretty detailed presentation that I do about CAT decisions and precedent case law, and there are many cases about board minutes, and I can send them to you and let you know what they say. So that's what I think the tribunal would do. Can I recall that the case law? Yeah. So I don't have it at in the tip of my tongue, but if you send me an email, like I said, bchaplick@HLD Lawyers, I will look up the cases from my presentation and I will flip them to you. And the other thing you can do is you can go on Canley, CANLII, and they have a link to the CAT decisions, all CAT decisions. And in fact, there's a link in my video description below to a Canley case. You can see for an example of one. Click on that link, find your way into the search function that just searches on Ontario CAT decisions, and you can just type in, search board meetings, and you'll get a lot of hits. It won't all be relevant because a lot of cases ask for board meetings, but you can actually read the cases and see what happens. But even if you search the word draft, I think you would find a lot of what you're looking for. But I've done the research already, and I can send it to you. So there you go. I think you got a good defense. Sophia, is there a good article trying to promote the standard unit bylaw? Owners usually get intimidated by the sub, thinking it is against them. there are lots of articles written about standard unit bylaws by various condominium lawyers over the years. I would say that you probably want to have something specific to your bylaw distributed to owners. So what I would do is the best person to write that letter is your insurer or your lawyer. Like your insurance broker, HRINs, for example, will write you a really great letter talking about the benefits of standard unit bylaws and how they bring your costs down. But you also just want to draft your standard unit bylaw in a reasonable way. And I think there's been a shift away from the empty box standard unit bylaw towards something that is more inclusive and includes more finishes. So if you're promoting an empty box standard unit bylaw where everything is an improvement and everything is excluded, you're rightly going to get a lot of pushback from owners. And if you're putting one in that has a lot of the normal finishes included and represents something that owners would find to be reasonable, then you're not going to get as much pushback. And I think that that's really the right approach, given the way that the industry has sort of shifted towards more of a compromise on the standard unit bylaw and being less aggressive on them. Because there was a moment in time where everyone wanted an empty box standard unit bylaw, and I think that there was pushback from the insurance industry saying, no, don't do that. Your bylaw has to have a basic habitable unit. Catherine, how long should we keep COVID-19 screening questionnaires? Oh, like after they've been signed? That's an interesting question. How long do you have to keep them for? There is a specific regulation in Toronto about how long you have to keep them for. Sorry, Catherine, I don't remember off the top of my head how long it is. I don't know if it's like 30 days or 60 days or 90 days or 6 months, but I have to look that up for you, Catherine. There is a letter of instruction from Dr. Eileen de Villa, and it's dated, I believe it's dated like January 4th or something like that. I don't know the exact date, but there is a letter of instruction from the City of Toronto's Chief Medical Officer of Health talking about how long she wants you to keep those COVID questionnaires. I don't know if it's 30 days, 60 days, 90 days, or 6 months. I'm sorry, Catherine. I have to look it up for you. But I would say for now, keep them. For now, keep them, and until we can find that letter of instruction, then we'll let you know which ones you can discard. It's for sure more than 30 days, like at least that or more. But I'm not sure how much more than it would be. You would think after 30 days it wouldn't be relevant anymore, but I'm not sure if you have to keep it a little longer, so I don't want to give you the wrong information. But we got to look it up. It's in her letter. There's like a whole protocol for how long you have to keep this stuff. Fabio asks, Brad, did you miss my question above regarding the dryer vent? I did miss it. Can you type it in, Fabio? I don't see it here in my chat. Fabio, I don't see your question. I'm sorry. If you type it back in again, I will look for it. I didn't see it. Dinny, hi Brad. Is it correct to say that if a unit owner casts an electronic ballot, the ballot is irreversible? It depends on your software. Some software will allow you in an electronic meeting of owners to change your vote on the electronic ballot right up until the election closes, and others you submit it and then it's gone and it can't be changed. So different companies do have different software systems that allow things to be either open or not. So you have to consult with whoever you're using. So I would say it is not correct to say that if a unit owner has cast an electronic ballot, the ballot becomes irreversible. It will sometimes be true, but it's not always true. Lori, can we use Section 117 to enforce a mask policy? So, Section 117, familiar to me and Lori, but for all of you, is the section of the Condominium Act that prohibits dangerous activities on the property. So, yes, you can use Section 117 to enforce a mask policy, Lori, and we do. And you can also just use the fact that there is a governmental order that requires it, an emergency order under so there's in the lockdown order provincially, and also there's a municipal bylaw in most regions in Ontario, including Toronto and the GTA and all the surrounding areas. It's required by law to have a mask, but then you would say, well, what if we want to have something a little stricter? Can we rely on Section 117? Answer is yes, and you can, and we do. And that allows us to enforce it, in accordance with the Condo Act. The other thing, Lori, is often condo declarations have language similar to Section 117 about not permitting anything that is dangerous or could cause a nuisance or interfere with other owners, and we use the declaration provisions also to enforce mask policies. And that's nice because often there's something in the declaration that says if you breach the declaration, then you can be held liable for costs. And so we use the existing lockdown order, we use Section 117, and we use the language of your declaration and rules, all to enforce mask policies. And that's how we do it. Great question, Lori. Sophia, is your opinion the same on releasing non-approved financial statements and requests for records? Okay, so when you say non-approved, we have to know exactly what you mean. So when we're talking about releasing records and financial statements, if you're talking about the audited financial statements, you do not have to release them until they are required to be provided to all owners as part of the next year's AGM. Or you might even say perhaps once the audit's completed. But if your annual financial statement, if people are requesting as a core record the audited financial statement, then you would say not until the audit's complete and we send out the notice of meeting package. If someone asks to see the unaudited financial statement, you would simply say that it's actually with the auditor being audited, right? So it's not available. And then if someone wants to see the unaudited monthly financials, that is a record that you would generally provide. It's not that it's not approved, it's just unaudited, and you would redact any of the receivables showing the unit owner's information and what's owed. So that's what you would do. Generally speaking, financial records, you should be providing them. And for the unaudited monthly financials, we do say to provide them. If you produce them, they're a financial record. You're not required to hang on to them, but it falls within the category of things that should reasonably be produced. So that's my answer for unaudited monthly financials. Sophia, they're not core records, so you can charge for copying and redacting, but the audited financial at the end of the year is a core record. Different rules apply. So hope that provides some clarity. Fabio, is the cleaning of dryer ducts the responsibility of the unit owner or the corporation? Check your declaration. How do I know? Have to check your declaration, Fabio. Responsibility for maintenance and repairs is different from condo to condo. It's going to depend on your unit boundaries. It's going to depend on the repair and maintenance provisions in your condo declaration. You have to check. If you're not sure, ask your condominium corporation's lawyer to do it. I can do it. It takes me 10 minutes, to go open up your declaration, find the provision, cite it back to you. We'll let you know real quick. Not a complicated opinion, but you got to check your declaration. Depends. Changes from condo to condo. Usually the condos do it. Usually the condos will take it over, even if it's supposed to be an owner responsibility, because it's a health and safety thing. You don't want to start a fire. So usually the condo does it. Okay. So we talked about a bunch of questions. Let's talk a little bit more about case law. I want to talk about a case from the Human Rights Tribunal of Ontario. It's about Christmas decorations. I know it's February, but it relates to all kinds of holidays. So this case is helpful all year round and for everyone. So the case is called Landau, Landau, and again, link to the full decision in the video description below. And in the Landau case, the unit owner claimed religious discrimination because the condominium corporation put up what the owner described as religious symbols in the common area that made this owner feel second class because she was not a Christian. And so the religious symbols included white lights on a bush that was outside, lights on a tropical fake plastic tree that was put into a prominent location, red poinsettias in the common areas, and then there was a thank you fund for the staff, which was conspicuously not called like a Christmas bonus or anything like that. They used a sort of neutral language. And there was some imagery that included candy canes and Santa hats. So the question was, did the decoration of the common elements and the use of Christmas imagery violate this resident's human rights? And the answer, of course, is no. But why? So basically, the tribunal held that based on past precedent, there's a case called Islamic Schools Federation of Ontario versus Ottawa Board of Education, which stands for the proposition, in the Islamic schools case, they were saying that having a break in the school year around Christmas time was discriminatory because it gave priority to Christmas as a religious holiday and didn't, for example, there wasn't a school break at Ramadan or other, cultural times, right? And so it was giving unfair prominence to Christian religion. And in the Islamic Schools Federation case, the court held that basically, although Christmas was historically a school break for religious reasons, that it's now both a religious and a secular holiday, to the point that there's no longer an assumption that something that evokes Christmas is actually religious in nature, like just something like Santa Claus, for example, is not Christian per se, and it's just part of our secular society. And so that's what the tribunal relied on, and held that, having poinsettias and white lights and a thank you fund, none of this was overtly religious, and that therefore Ms. Landau's rights were not violated. And also that the Condominium Corporation went to great lengths to use, holiday or neutral language. There was no overt Christian imagery, no images of Jesus or anything like that, or crosses. And that other holidays like Hanukkah around the December season, and Passover, which typically happens around the same time of year as Easter, and other, not just Judeo-Christian, but all sorts of other holidays were recognized by the condominium. Not every single holiday known to humankind, because of course then you'd be celebrating every single day, but many, and that none were rejected. Anyone who wanted to have a holiday recognized was allowed to do so. And so as long as you were taking this kind of an inclusive approach, and as long as you were not using overtly religious imagery in the common areas, that there was no discrimination. And I think that this decision would come as a great relief to many condominium corporations that allow holiday decorations, or perhaps have recognition of holidays in the common areas. It's sort of, maybe it seems passé now to talk about this stuff in 2021, but for many years there were a lot of big arguments about putting Christmas trees in lobbies, and did you have to have a Hanukkah menorah next to it or not, and would all of this be acceptable in the eyes of the Human Rights Tribunal. And I think we're now at the point where the Human Rights Tribunal has said, yeah, we don't really take exception to this kind of thing. We're more concerned with meaningful substantive discrimination, and not this kind of, what I would describe as like a sort of a trivial complaint, right? Like I'm not a Christian person. My family wasn't Christian, and I'm not Christian, but I don't look at Christmas trees in malls and think to myself, oh, they're discriminating against me. It's just, and I think that's how most people would react. So if you have a unit owner who's saying that the the lights in your lobby or whatever are discriminatory, go talk to your lawyer, get an opinion, but know that there's a case out there, the Landau case, that says you're probably in pretty good shape, and that you can respond to the owner sensitively and accordingly, letting them know, like, no, we don't have to take this stuff down. We're allowed to have it up, and the Human Rights Tribunal has looked at this specifically in the context of condominium corporations and said that it's okay. So, good case in my decision, in my view, at least. Okay, let's get back to some questions. Lior, can we back charge legal fees to a tenant that break the rules on a regular basis. So, okay, tricky. So, Leor, it depends on your condominium declaration, and it depends on the conduct. So, let's say in your declaration it says that if a owner or resident breaks the rules and the condominium corporation incurs a cost, including legal costs, it's added to the common expenses. Pretty clear language that you can do this, and I would say yes, you can back charge the legal fees. The legal fees have to be reasonable, and you have to be able to demonstrate quite clearly that the tenant has broken the rules and that you've taken steps prior to involving legal to warn them. So you at least sent 1 or 2 management letters and said, if this continues, you'll be responsible for costs. If you were to do that and then charge back a legal letter, I think you would be in good position. And you'd also have to make sure that the unit owner was warned, because ultimately, if you're charging back costs, you're adding them to common expenses, you're no longer dealing with a tenant, you're dealing with the unit owner. And so again, you'd have to give warning to the unit owner. And I think if you did all those things right, you would be in good position. But there are some cases out there that are critical of condos that do this, so you have to really you have to follow the right steps to make sure that your charge is reasonable, that the owner was warned, that the conduct truly is a significant breach of the rules. It's not something trivial. So, under the right circumstances, answer to your question, yes, you can back charge. Cheng Wang. Hi, Brad. Will the corporation be held liable for the security guards at the concierge desk who may catch COVID-19 without proper plexiglass barriers? The concierge is in the middle of the lobby. So I'm not as concerned with the plexiglass barrier as I am concerned that the concierge is wearing a mask, and that there's markings on the floor to keep a 2-meter distance. So the law on this is there is recent legislation passed in Ontario that says that employers like condominium corporations are not liable for people getting COVID in their property if they follow all public health guidelines in good faith. So in your case, that means you actually have to look at what the guidelines are, including additional letters of instruction for all workplaces in the City of Toronto, which is the letter I was referring to earlier from Dr. Eileen de Lella. And you have to see, these are all the health and safety requirements I have to follow. There have to be health questionnaires, people have to be wearing masks, there have to be floor markings, all of these things. And if you follow all of those rules, and I don't think plexiglass barriers is one of them, but wearing masks is. And if you follow all those rules, then you're not liable under the legislation that exempts employers from liability. But if you don't follow the rules and the person catches COVID because you were not following public health recommendations, then you do not have the benefit of that legislation and you could be liable. So that's really the answer, is you have to make sure that you are diligently and precisely following the public health guidelines. The law says that you do it in good faith, but I would say for you it's not just enough that you guess, you really have to do everything that's necessary, do the due diligence, and if you're not sure, ask for help and we will help you. So you have some protection, but it's dependent upon your action. WC. Thanks, Brad. Should management contracts usually have 60 days termination notice, no cause termination, or is it reasonable for 90 days or more? 60 days is the norm. Lots of management companies have 90 days no cause termination. That's fine too, but 60 days is the norm. That's what I recommend. But it's 60. It can be 60 plus. So it's 60, but like effective as of the last day of the month. So if you gave notice now in February 10th, then it might say that it would become effective on April 30th. So that's Sarah in the background. All right. Just asking if I want a sandwich, and I do. So WC, that's the answer. Is it can be 60 days, or it's often 60 as of the last day of the month. It would be normal, and 90 days is also fine. Okay, WC, should it be similar to other contracts such as security and cleaners? I don't have a problem having shorter termination provisions with security and cleaners. I think 30 days would be fine. So the 60 days for management is the industry norm, but I think Even shorter would be fine for cleaners and security, because once you decide that you want a cleaning company or a security company out, you're not really keeping them there for the notice period. You're getting rid of them immediately, but you have to pay them for that notice period. And so you want that period to be as short as possible, and I would want to keep it 30 days or less for contracts like security and cleaning. No fault termination, bang, 30 days. And then basically just you can fire them anytime and just pay them 1 month. And then you're done. So that's what I would want to do. WC, do you recommend corporations close off public amenity washrooms to residents due to COVID-19 restrictions, along with other amenities that are closed? My understanding is that amenity washrooms are permitted to be open. In terms of whether I think they should be closed or not, I would leave it up to you. If you have the resources to frequently clean them, like hourly, basically, then you can leave them open. If you do not have the resources to keep them frequently cleaned as a high-touch and high-contact area, then you should not have them open. That would be my recommendation. Is if you have the resources to clean them, you can keep it open. If you don't have the resources, close it, because you can't have it open if it's not being frequently cleaned. And I would say frequently in this age means, every 1 to 2 hours. Okay. Property manager asks, a plumber was called to service a backed up sink on behalf of the owner. The backup is not a stack related, therefore charged back to owner, ... Well, okay. So this is something that happens a lot. So I guess the question is this like a proper back charge? There's a couple things going on here. So an owner calls you and says, my sink is backing up. It could be a stack issue. So the second part of this question, if the chargeback was not mentioned to the owner before the call, does the owner have the right to refuse payment even if this is an in-suite issue? Okay, yes, the question is as I thought it was. So this is really complicated, but I'm going to try and break it down for you. The owner did the right thing by calling management and saying, my sink is backing up, because it could be a larger issue in the building, and the owner is letting you know. So that's great. Then management does the right thing by having the corporation's plumber investigate the cause of the backup, because it could be a common element issue and you have a duty to investigate. So far everyone is doing the right thing. But then you find out that it's the unit owner's responsibility, and I guess at that point, while the plumber's there, they might as well just fix it. And now you have this charge for, let's say it's a couple $100. And the question is, well, the owner's saying, well, I didn't say you could call a plumber at my cost. I was just telling you about the backup. I would have called my own plumber and they would have done it cheaper. But you didn't know at the time whether it was a common element cause or not. So that's why the condo sent the plumber. So now you have to deal with it after the fact. I mean, look, in hindsight, if you were to do it again, you would say to the owner, your sink is backing up. We can call a plumber. If the plumber determines that the cause of the leak is a common element stack, we will cover the cost. If the plumber determines that the cause of the leak is not the common element stack and is in fact local to your unit, then you will be responsible for the cost. Do you agree? Owner says yes, and then you go ahead. Owner says, no, I don't agree. Then you say, okay, then you call your own plumber. And the condo calls its plumber to investigate the common element stack, and the owner calls their plumber to investigate their thing, and now you have like duplicate work perhaps. So that's not great, but that's what you would have to do if the owner said, I don't agree to pay for your plumber. So the best case scenario is that you've covered this off in writing before you call the plumber, assuming it's not an emergency. If it's an emergency and it's a leak, condo call the plumber, charge them back. You're going to be able to do that. But if it's not an emergency situation, you want to get it sorted out beforehand. Who's going to be responsible under what circumstances? And because the owner then might rightly say, no, I'll call my own plumber because I can get someone cheaper than what the condo is going to do. And they should have that right. So none of this is discussed. Now it's after the fact, and you want to charge back the cost, and the owner says, well, I never agreed to this. You called the plumber yourself. I think the owner has a point, and this is not a situation where you would want to lien. It's a situation where you want to, work out a solution that's amicable and say, look, we called someone, they did work for you, you received a benefit, you owe us something, and maybe you end up having to split the cost or do something like that. But it's really a best practice as a manager to explain in writing to the owner before you call the plumber that they're going to be responsible for the cost if it's determined to be a unit owner cause to the sink backing up. So it's sort of hard to do all of that in the moment, but it avoids the situation you find yourself in now. Hope that answers your question. Dinny, can a condo corp put a lien against a unit for a little amount as $150? Yes. If you said $15, I'd say no. But $150? Sure. Go ahead. Do your lien. I mean, try to collect it without a lien, for sure, right? I mean, because even just the notice of lien is going to be at least $150, probably more. And then registering the lien itself could be like $600. It's not nice, and you don't have to lien it, but can you? Yes. Absolutely. $150, sure. So, lesson learned. Yeah, hard. Look, it's a lesson learned, but it's a very common thing. It happens all over and over and over again. This lesson about calling plumbers and checking with the owner and getting in writing, this lesson will be learned over and over again for as long as there is condos. This is going to happen over and over. So don't worry about it. Okay. The last little thing I wanted to talk about before we wrap up, if there's some lingering questions, I'll answer them, but it's getting a little late now. We've been going for a while here. Is reopening is coming, right? It's coming either next week or the week after, depending on where you are located. And what does that mean for you as boards and managers? How do you get ready for it? The short answer is until we see what the new regulations look like for reopening, there's only so much planning we can do. So are you going back into lockdown? Are you going from the tight lockdown to the normal lockdown? Are you going into red? We don't know yet. We don't have all those details. So we're still waiting for more information from the government. In the meantime, I think it's useful as management to communicate to owners to say, look, we know that the government has announced changes and reopening coming as of, February 22nd or some other date, depending on your location. We will examine the new rules when they come out, and we will respond. And just to say that, to let people know that there's going to be some period of a lag, because the rules are published so late, right as the changes are taking effect, that the condo needs time to implement and to reopen, and that the reopening is not instantaneous with the government reopening. Whether your gym or your pool reopens, it's going to be in accordance with the law, and there's going to be a period of time where it is legal to have a gym open, but your gym's not open yet because you haven't been able to put in place all the things that you need to do to get your gym open. Even for a swimming pool, you might have to give 14 days notice before you're allowed to open the pool to the health board before you can reopen a public pool if it's been closed. And so all of these things exist. There are lags in the system. You want owners, you have to communicate this to owners that there's going to be a lag, that even once it's legal to open the pool, we still need to give 14 days notice before we can actually open it. There's going to be a delay. And I think if owners understand that, then you're going to have a much happier community. They know that you're on top of it. They know that you've turned your mind to it, and you're not just spaced out because they haven't heard anything from you. So turn your mind to that. Get those letters ready. Think about what you want to say. If you want help writing them, we can help you write them. They're going to be specific to your individual condominium community based on what you have closed and what you predict will be reopening. Get them ready to go. New rules get announced, bang, out goes your letter. People know there's going to be a delay, and then they are not surprised when, day one of reopening comes along and the gym is still closed because you haven't had time to implement whatever the new rules are for reopening your gym. So that's my best advice to you on how to reopen. Be proactive with your communication, manage expectations, let owners know what's coming, and they will be understanding. If you don't let them know what's coming and you don't communicate, they're going to be upset. So, let's see what we have here. Diane asks, is the corporation advisable or responsible for advising residents of the death of another resident of the building who was in the hospital? As a follow-up, the death was related to COVID-19. No, that is not your responsibility to advise owners of the passing away of one of your residents. It could arguably be contrary to that person's interest to have their life remain private, and I would not do it. So don't do that, Diane. It's not your role as the condominium manager to report on the health outcomes of your residents. Health outcomes are among the most private of our personal information, and it should not be disclosed. Certainly not without. I mean, if the family wants to publishes an obituary or something, and you want to share post the obituary that's published on the newspaper, different. But just your own notice or death notice to owners, no. Okay, Mark, what is one big change you wish to see in condo law? I'll give you one, Mark, but you might not like it. No pets void. What do I mean? In landlord and tenant law, there is a clause in the Residential Tenancies Act that says anything in a lease that says no pets is void and of no force and effect. So basically, tenants are allowed to have pets even if the landlord writes no pets in the lease. I would love to see no pets void put into the Condo Act, and I think that the existence of rules banning pets. I'm not talking about like reasonable restrictions on pets, like your dog has to be on a leash or whatever. Cool. Even restrictions on the number of pets make sense. To say like you can't have more than 2 pets or something like that. Fine. But just to have something in a condo declaration that says no pets, to me, that's bad. That's bad writing in your declaration. It's a bad rule. It's nothing but conflict. There are many reasons for people to have pets. The overwhelming majority of pets cause no harm in condos. To the extent that there are specific pets that do cause a nuisance, there are rules to deal with them. And I just think that if someone has like an indoor cat or a dog that doesn't bother anyone, doesn't bark, and it's well suited to condo living, people should be able to have those pets in their units. And I think no pets void would make the condo world a happier place. So that's my secret, not so secret now, wish to see a change in condo law. I don't know if we'll ever see it, but people ask me all the time, and that's my answer. No pets void. All right, everyone. Thank you so much for your amazing questions. We'll see you again soon. Keep your eye out for our special updates. We'll have one going out as soon as we have more information about reopening and exactly what it's going to look like. We will continue to keep you guys apprised as and when there are developments, and we'll do some case law videos as well. And thank you all for coming. Enjoy, and we'll see you.